Over the last 2 decades, British authorities have exploited fears and prejudices, particularly towards Muslim communities, to build an infrastructure of authoritarian laws, also known as counter-terrorism laws. Schedule 7 is one such law, a mass surveillance power that suspends due process and deprives citizens of basic rights at the border. Police can detain you for up to 6 hours without suspicion, you have no right to remain silent, and failure to comply with any aspects of the stop can result in a terrorism conviction. Fahad Ansari, a respected lawyer handling sensitive national security cases, was stopped under this power and had his work phone confiscated. He has launched legal action against the government for this targeted stop, where in court it was implied that it was a direct result of his litigation against the government, specifically representing the Palestinian resistance and political party for deprescription. In a hearing this week to stop police accessing his device, a judge ruled he would allow the police to present their evidence in total secrecy, unseen by the claimant, a mechanism called closed material procedures, introduced in the context of a so-called war on terror, a violation of rule of law principles. This marks an unprecedented assault on the legal profession under the guise of combating terrorism. On the ground, Palestine Action, the most effective pro-Palestine movement, was proscribed this year under terrorism powers by the British government. This has prompted mass outrage from across the political spectrum. Over 2,000 members of the British public, including 2 directors of our organisation, have willfully defied the law in order to protest the ban, resulting in thousands of arrests under terrorism powers. This simple act of civil disobedience exposed the reality of counter-terrorism powers as tools of repression rather than security. The prescription followed a shift starting last year, whereby British authorities began using terrorism-related powers to arrest and detain Palestine Action activists at the behest of Israeli weapons manufacturer Elbit Systems, which was a primary target of their direct action campaign for its role in arming the genocide in Gaza. One of their high-profile cases, the Filton 24, demonstrates an egregious example of such abuses. They've been held in pre-trial detention for over a year, a suspension of the presumption of innocence. Though they haven't been charged with terrorism, a terrorism connection was added to their case to aggravate any potential sentence. As a result, they have faced harassment and abuse in prison. Their case has prompted the Working Group on Enforced Disappearance and also 3 UN Special Rapporteurs to intervene and say that their detention under terrorism powers possibly amounted to enforced disappearance, that the British government treating direct action like terrorism risks chilling the exercise of freedom of expression and opinion, and that the definition of terrorism in the UK is overbroad and counter-terrorism laws have been used to circumvent procedural safeguards. In conclusion, rather than escalating repression, the British government should urgently move towards abolishing authoritarian terrorism powers, a call echoed by its previous independent reviewer of terror powers itself.